anyone over here, what do you understand about contract? Anybody would like to give any inputs about what they understand about a contract? What does it mean? My meeting of minds, I'll say, to achieve a common goal and agreeing on doing it in certain terms and conditions, that will be an agreement. However, when you move towards enforcing that agreement in law, constitutes a contract. So that's one part of the definition of a contract. Now, I understand in media law, again, as Jamshed rightly said, that what is entertainment in media law? When I was in my university, we never really had a compulsory course. It's still, in fact, in majority of the universities, is an elective course because it does not have an independent standing. Largely also because it's one of the big media and entertainment is a unregulated sector to a great extent. What are the essentials of a contract? To start with, always remember it's offer and acceptance. Application to media law would be, if I make an offer to you to act in my film, I am making an offer which is subject to acceptance or denial. Unless the other party accepts it, it is not a contract. That is one of the most essential elements of a contract. I think the relevance of contracts have gone higher. So, and also, I mean, with the kind of disputes and litigation that has come up in last couple of years, the importance of contract has become rather higher. So, offer and acceptance is largely one of the most important things. Second essential of a contract would be intention to create a legal relationship. The intent in the agreement needs to be very, very clear that this will lead into a certain valid legal relationship between a party, which I will describe in the course of time. A third part is lawful consideration. Now, what is a lawful consideration? It could be money, it could be in kind, it could be in terms of services, but it is important to have, very, very necessary to have consideration in your agreement in any format as long as it is under the provisions of law. A consideration within the premises of provided law in this country, you need to have consideration in an agreement, otherwise that agreement is void. Moving forward, the parties need to be competent parties. As Jamshed rightly said, that what was the requirement of a contract to understand who was getting into an agreement with each other, who were these people. How do the kids now, you see so many kids in the movies, in the industry, in television, how do they come and work? If a kid goes and sign a piece of paper, that's not, the kid is not competent to enter into an agreement. They will have their guardians, and only an adult can get into an agreement. So competent parties is another very important aspect that one needs to be careful about. Free consent. There needs free consent. I'm sure it's not really applicable in your case unless we all work for a livelihood. If I'm not being paid a certain amount, which is a problem in the industry, that you're paid very less, that cannot really be, I cannot really count it as free consent. But free consent with respect to coercion, with respect to fraud, cheating, if you're misrepresented, if you were told that, for example, a script, you were shared the script, and on the basis of what the script said, that this is how it's going to go, this is the sequence, this is what it's going to be, and based on that representation provided to you, you entered into an agreement, and tomorrow there is a vast difference, something that you're not comfortable with, something that you were not expecting. That is misrepresentation, and that would constitute to challenging the agreement itself. So it's very important to understand what is the free consent over here. Moving forward, it's lawful object. Now, what is a lawful object? Anything which is not forbidden by law. Say, so okay, it's a state law. Gambling in some places are allowed, in some places are not allowed. What is your nature of engagement? As I cannot engage you for terrorism activities. I cannot engage you to do any kind of criminal activities, anything which is against the public policies, anything which is against the government. So these kind of things constitute a lawful object. What is the object of your agreement? Certainty of meaning. Your rights and duties, it has to be a certain kind. For example, if I'm selling you an oil, I'll say I'm giving you 10 tons of oil. That's inconclusive. It is not certain. What would be a certainty? what kind of oil that you are giving. So you have to be very, very particular, and you have to be very detailed with respect to what is the objective. So all of these are interrelated essentials, which one needs to be very, very, very sure and thorough with. Then possibility of performance. You cannot enter into an agreement for an act or a service which is impossible to perform. If that is the case, and if you enter into an agreement without making it clear to the other party that it is impossible to perform, then it would also lead to misrepresentation, as I mentioned earlier, and hence your contract entirely would be a void contract. Then, any and every legal formality. If certain agreements require definite registration, now tomorrow if you have to challenge an agreement, if there's a breach of contract and you go to the court and say, I'm challenging this agreement or a contract, what is the legal formality? If the court will say, have you paid stamp duty for the certain amount? How are you coming to us to challenge an agreement when you're not even registered it in the courts of law? That's the difference that I earlier explained between agreement and a contract. That if you want the contract, if you want an agreement to be enforced in the court of law, you need to have it registered. 9 to 10 most important points one needs to look out in an agreement. If there is a violation of any of these main 10 essentials, then your contract eventually becomes void. So, very simple points without any confusion. These are the things you need to look into your contract. That's one part of why it's relevant to this industry. Now, this city, in fact, is getting people in hundreds, thousands, lakhs every single day. Unorganized sector, thousands of people, nowhere to go. And everyone's been used, misused, whatever. A successful singer, I think, has been paid 10,000, 15,000 rupees. They were promised an X amount, they were given a certain amount. They were promised an X thing, they were given a Y thing. This is the reason why a contract is very important. Because you need to negotiate, you need to pre-decide that what is it that you want. Otherwise, it's going to keep going into the unregulated sector that it already is. So, contract is essential. In fact, clients come to us and say that आप 20 पेज का contract बना देते हो. What is the relevance of 20 pages? Nobody has even bothered to pick up those 20 pages and see what's written. The rights and liabilities are so detailed these days that one breach somewhere can take you to court. So, do not run away from those 20 pages. I understand the language of that may be a problem for somebody for a layman to understand somewhere, but these are just simple rights and liabilities. You need to define for yourself. What is a contract? You decide what you want from each other. You don't need a lawyer to decide what you want from each other. That part needs to be taken care by you. You do it once, you do it twice, you do it thrice, you'll get used to it. So never ask for a 1-pager, never ask for a 2-pager, because you never know when things turn around. And when they do, then hell breaks loose. So always have a contract. I'm not saying run for 25 pages, but even if in those 20 pages, the arbitration, for example, Jamshed said arbitration clause was missing, which is right now an essential part of a contract. It takes away the whole, it is like a progressive litigation, I'll say. This is where the world is leading to. If you don't want to go to the courts, save yourself, go for arbitration, and you will be surprised how much arbitration is going on in media and entertainment law, which has saved the court's time, which has saved the petitioners and the defendants' time as well, because now they are time bound and because they are more effective. So these important points, they could be in 10 pages, they could be in 20 pages. Don't shy away from asking what you want. Be very descriptive in what you want, because even a word as may and shall will make a lot of difference when things don't go your way. Hence, the relevance of contract is of utmost importance in this industry. This is one step you can. This is rather the first step that you can take towards from making it to from unregulated sector to a somewhat regulated sector, I will say. And on that aspect, in fact, in my opinion, you can't even go 100% regulated, because the industry works on certain divide on certain factors which are beyond an individual. It's not a corporation. Okay, you may have a dharma, you may have a yash raj, but they're still handful in number, they're still in dominance, they're still few in number. They do, so, and now they have 100 other television producers. Everyone's requirement is different. Everyone's work is different. So you can't have a common slab for it entirely. But to a great extent, by way of these contracts, you can set industry standards, and this is how this, and put your foot down that this is how it works. If it doesn't happen this way, then all the labor laws that are being made, all the amendments in the contract, the Copyright Act, will not lead you to anything. Now, in the rights and liabilities, there comes your IPR aspect. That is something that you should decide for yourself. That's another reason why a contract is so important. Because even in between two partners, rather, if anybody over here is in a partnership with anybody, one needs to be very, very careful about your IPR and a contract between partners. Because everybody over here is creating a certain IP, something which will have a value in future, something which is growing. Now, if the one who's making it will have a divide amongst themselves, if there are two directors in a company, if there are two partners in a partnership firm, if you're making a movie, if you're making a web series, if you're in television, where does your IP lie? So before engaging into artists, before even starting a project, make sure that people who are doing it together in terms of ownership, you 2, 3, whatever the amount may be, they need to have an internal agreement to ensure where your IP lies, because the bottom line of your profession is only and only IP. There is nothing else is left if the IP is taken away from you. You could be a producer of 100 films. If you don't have the IP of it, then technically you're at ground zero. So your understanding with your counterpart in terms of how this project will lead and what would be an understanding between you two is the first and foremost important thing. Then comes to how to secure an IP, which I'll begin with. Then first of all, what is an IP? IP is an intangible asset that you have, which adds a certain value. It could be a goodwill. It's your identity. It's what you make. Of course, protected by law. And there are certain aspects of IP. It's copyright, it's trademark, it's design, it's geographical indications as well. So there are different levels on how you get your IP protected. So I'll start with branding. Now, simple question. Where's Deepa? There's a girl called Deepa I interacted with. So Deepa, what's your full name? Deepa Yadav. So if we are 50 people here, I believe there's only one Deepa Yadav here. I'm hoping. Deepa Yadav is a identity. She's a person. This is a reference for everyone to understand what I'll lead to saying what is a trademark, which is the whole point of a brand. The name of a brand, she is a brand. She is Deepa Yadav. And what she does is brand consultancy. We are 50 people. This is the geographical area I'm talking about. She is the owner of Deepa Yadav in this geographical indication doing brand consultancy. Hence, amongst us 50 people, there cannot be another Deepa Yadav doing brand consultancy in this area. This is what a trademark is, that within a specified goods and services that you provide or you sell, you have an exclusive name. So this shape, color, size cannot be repeated in any format. So this is what a trademark is, that within a certain goods and services that you provide, you have a certain identity. That identity reflects your quality, your service, you as a brand, and what you do. This is what a trademark in simple terms is. Media connect with this sign. This whole concept is their trademark. This is their brand. If I see it anywhere else, I'll understand this is them. But one needs to be very careful about that trademark is geographically controlled. If it's India, my trademark, this mark, is only valid in India. If I have to apply, if I'm expanding my business, if I'm, as they said, that they are global media exchange. Now tomorrow they decide to open an office, they decide to have a platform, say in Australia or maybe America or wherever. This name, in the kind of service they provide, may or may not be available in that country. There might be someone already doing something similar. So I cannot go over there and say, this is my mark. No, your mark is India. Your mark is in India and you belong to India. Now, tomorrow, if you're moving international, if you are working globally, then you have to apply for a separate trademark in a different country. Trademark is a graphical representation on my name or my logo, and this is how I protect myself and my brand, and this helps you grow your business in future. So how do we go about getting a trademark? Why I'm starting with trademark is that your brand is the most important thing that you need to form before starting any production house. Even for music, everybody is a professional in their own way. Everybody has their own brand. You could be a musician, you could be an actor, you could be a producer, a singer. You have your own brand. So always do your homework and start with your own brand. Work on it. It has to be distinct from everybody else. So trademark application is fairly simple. You design, it could be a name, it could be a logo, a design in a certain shape, size and color, and make an application with the trademark registry. If I would have gone for a registration of fun, I will not get it. I'll be denied outright. But a combination of terms, Fun Republic, it's a combination that I've made. There could be two generic terms, but a combination that I make of them makes it distinct. So media is one word. If you say, I just want media as my brand or a name that I want, I'm not going to get media because it's a generic term. But they have made a combination of word over here, which is unique, which nobody else has it. Hence, your trademark is at least you're eligible to have a trademark. Now, before anyone spends that money to file for a trademark, always make sure that you do enough. You run a search engine for trademark. You can pay the registry to do that. You can pay the attorney to do that, or you can just go online and do it yourself if you know how the portal works. It is very important because there's a major backlog in the registry. If you apply for a trademark today, I won't be surprised they'll come back after 3 years and say, fine, we have moved to step 2 now. This is the kind of backlog I'm talking about. In all, if someone's good luck, if you don't have any objections, if you don't come through any objections or any oppositions, then it will take at least 3.5 years to get your trademark. So today, if you're starting something new, if you want a brand, and you don't want to work on your brand after you've worked on your work, after you've made 3 films, after you've made 5 films, you don't want to work on a brand then. Because by that time, someone else may have already registered with your name. Then you'll have to go into the entire, and by God's grace, if you become big, which it's highly a possibility that it may be infringed. In that case, you'll have to go back to the court and say, I was a prior user. And again, you have to establish the fact that how it is infringed. It's harder when it's an unregistered mark. So it's always better that work on your brand first, work on your identity first, and grow from there. This is why I started on trademark first before going to Konnect. Sitting here, you can apply for a trademark in another country at an X amount. And in fact, you can apply to, say there are 91 signatories to that protocol. Apply to wherever you want to apply. This is a way to secure yourself in order to go global. If that's a part of your business plan, then while making an application here today, try to cover your possible opportunities as per your business plan. If in a year or two's time you want to, this is a part, if this is how you've planned. Trademark is a geographic concept. And after having business in India for 20 years, now people are moving abroad and they're facing difficulties with their identity in another country altogether. So now, since we have this provision in the Trademarks Act that you can have an application applied from here, it doesn't matter at what stage your business is. If you would see a potential, you must work towards it. So that's pretty much the trademark part. Now moving on to copyright, which everyone has been talking about since last 2 years, since 3 years rather, since Mr. Javed Akhtar got a major relief and changed the law itself. So What is a copyright? So it is an exclusable, assignable right that I have for something that I create, something which is original, something I'm the first author of, ranging from literal, dramatic to artistic work, and even computer programs. So, what right do I get when I say that this is my copyright? What does it entail? It means I can reproduce, I can make adaptations, I can translate, I can do any kind of make a prequel, sequel, or do anything with it. I could even throw it out of the window if I want, and nobody can touch me. That's pretty much what my right is, what is in terms of copyright. Now going back to contracts, since I've come on copyright. I'm, as Jamshed rightly pointed it out, that I am the author. Who is the first author? If this is my diary, whatever is written in this diary by me, as long as it's original, I'm the first author of it. So, simply put, you need to define where where does your copyright lie in your contract. If I'm the musician, now the act provides so that even if you get into an agreement, as long as you're the first author of it, of the music that is being produced by you but commissioned to a film, any contract which waives your right, if it uses, especially if it uses term waive, because it's a very loosely used terms in agreements that I give away, I waive my right, I will take XYZ as money as a total royalty, and I'm going to give away my right as a musician or whatever. Just it's a void contract. At any stage, you can challenge it because it is a void contract in its own nature. You, no matter if you've signed the contract as a waiver, it cannot be waived if you're the first author and if you can establish it. So that's a very that sorts everyone's questions on royalties, on how royalties will be divided in future, which the copyright board will decide what percentage would go where. Then there are aspects of music composers, writers, technicians. How will it get spread out? But at least now, at least we know that the musicians are going to get the royalties, and it's not going to be strictly with the producers. So copyright is something that only in a contract you can define where it lies. It's intangible. I'm not going to run after it looking kahan gaya mera. Ek picture chal rahi hai, that movie, that cinematographic movie is the entire copyright. However, the songs in between, even if they're commissioned, even if you're paid for it, of course the musicians are paid for it. Even then, nobody can take away my right to take loyalty from them, loyalty away from them. However, if a musician is given a certain indication towards, if they're given a music piece by the producer, at that point, yes, the copyright may vary because the musician is not the first author in that case. So if you're given a certain indication, if you're given a certain piece, if you're given a certain base, be careful on where the copyright would lie, because that's a very thin line. You may have they may have asked you to develop on it. Whether that makes you a first author or not becomes a big question mark. So, copyright with respect to media and entertainment law is with the producers who make the entire cinematographic film. I'm talking about broad areas where it usually lies. An artist performing, an artist by I mean actor, an actor performing will not have a copyright because will not have its own copyright because that's a part of a cinematographic film which is directed by a certain person, which the direction has been given, the script has been given to you. You are enacting it. Yes, your own style is a different issue, but that style covers, that style is a reproduction of what the director has told you, what the brief has been given by the producer. So an actor per se cannot claim a copyright over a certain part of the film because the film itself is a copyright. All aspects of acting in the film goes to the producer. Now it's up to the producer. If an actor is sharing the rights with the producer, that's a different story altogether. But an actor, yeah, even in theatre, even in a theatre, the director, the person making the play, that person will have the copyright, not the artist performing on the stage, because he's been fed in that information. He's not the first author of that information which has been put out to the public. So that's these are the thin lines one needs to identify in terms of copyright. What is the duration of a copyright? If you make a film and you're the for example, I'm the author of the I'm the copyright owner. I've published a book, for example. My book my my book will have a validity of 60 years on from the year that I die. So your lifetime plus 60 years is the duration of anything that is published. The literary work that is published, whoever the first author is, that's the copyright duration that you get, the term that you own. For the films, it is 60 years from the year the movie is published. The movie is given to the public. For 60 years, it has copyright protection. Interestingly, now there has been, from the amendment perspective and from the music perspective, anyone making covers of songs. Earlier, there was a limitation of 2 years that songs that have been published since 2 years, you can only make a cover after the song has already been out for 2 years. Now that's increased to 5 years. You cannot make a cover of a song which is only been out in the public domain since below 5 years. Once that song is published, 5 years thereon, after that you can make a cover of that song, and that also in a very detailed procedure. Not how, see, that's the problem now. YouTube and all of these, how technology is advanced, everyone's been using platforms in various manners very loosely. Nobody understands what the law behind it is. So in order to avoid any kind of a lawsuit in future, which is going to be a high perspective, since the musicians are becoming very, very proactive with their rights, you need to be careful on what you're putting, where you're taking from, are you giving credit or not. All these things would entail into infringement of copyright if you go wrong anywhere. So that was the concept on